Students, today we will discuss private international law. First, we will discuss introduction. Private international law is that branch of law which is administered by the court of nations over the citizens or individuals in cases involving a foreign element. Private international law often referred as conflict of laws also. In today's modern era, almost every country has its own system of municipal laws as well as its own system of conflict of law. It, it comes into operation whenever the court is faced with a claim that contains foreign element. It is applicable only on civil matters, not on criminal matters. National laws are the primary source of private international law, but it is also embodied in treaties and convention, for example, Hague Convention on Private International Law. Now we will discuss meaning and definition. In the case of R. Viswanathan versus Syed Abdul Wajid, Justice J.C. Shah observed that private international law is not the law governing relations between states. It is simply a branch of civil law of state evolved to do justice between litigating parties in respect of transactions or personal status involving a foreign element. Its rules vary in nature of things differ from state to state. But by the Committee of Nations, certain rules have been recognized as common to civilized jurisdictions. Through part of judicial system of each state, these common rules have been recognized as common to civilized jurisdictions. Through part of the judicial system of each state, these common rules have been adopted to decide disputes involving a foreign element and enforce foreign judgment, often as a result of international convention. Nature and scope. Private international law is that part of law which comes into operation whenever the court is faced with a dispute, that it comes into operation whenever the court is faced with a claim that contains foreign element. It is applicable only on civil matters. Thus, private international law deals with variety of cases such as contract, marriage, and divorce, child adoption, etc. And when parties cannot resolve their differences amicably, then three types of questions may arise in such cases. The first question which may arise, whether the court has jurisdiction to deal with the issues before it. Second question may arise, by what system of law should the issue be decided. Third, whether the judgment of a foreign court should be recognized or enforced. These are the three main questions which may arise in a case. Area of involving in conflict of laws like law of obligation, right, contracts, torts, etc. Property and transaction, property, intervoice, succession, matrimonial property relations. Number three, family law, marriage, divorce, custody of children, etc. Now we will discuss the foundation of the rules of private international law. First is students, Committee of Nation as foundation of private international law. Doctrine of Committee of Nation is basis for applying the principle of conflicts of laws. In the cases, in the case of Satya versus Teja Singh, Honorable Justice Y.V. Chandrachud observed that Indian rules may require foreign law not as an act of courtesy but on consideration of justice. Second, foundation is the equal treatment. Principle of private international law is that a case will be treated in same way under the appropriate law, irrespective of the forum of decision. Thus, a marriage will be adjudicated upon in accordance with the law of place where it was entered into, no matter where the adjudication take place. Third foundation is convenience. For the sake of convenience and expediency, report is made to private international law. Fourth is interest of justice, sovereignty and social needs. Justice is broadly a legal reflection of ethical and moral values, conditions by time, place, and circumstance. For the sake of justice, the court goes beyond the geographical limits of its sovereignty. It is really a conflict, if at all, or at least a discrepancy between consideration of sovereignty and justice. Great injustice could result if the law of courts country is applied where justice require that the law of another country be applied to the facts and circumstances under adjudication. Genesis of development of private international law in India. Students, before 1772, India has had an older development of private international law, peculiar to her historical, political, and social circumstances. This modern private international law began in Bengal Presidency when Lord Warren Hastings passed regulation of 1772, and from then there has been evolution of rules to regulate interpersonal conflicts of laws, considering the personal laws of different communities in India. By this regulation, Lord Warren Hastings had attempted to introduce impartial, fair, and inexpensive administration of justice. This regulation laid the foundation of a sound judicial system, wherein Section 23 of this regulation prescribed application of Hindu and Mohammedan laws to Hindu and Muslims in their respective matters relating to inheritance, marriage, case, and other religious usage and institutions. Before independence and till its recognition as a state, India was a federation between India and native princely states, having distinct legal system. As a result, conflictual questions often arose in the area of law and administration of justice, particularly by recognition of foreign judgment. Because at that time, a judgment passed by a princely state was foreign to the court of British India. This can be seen from the provisions of Section 13 of the Code of Civil Procedure, which deals with recognition of a foreign judgment. Now, students, we will discuss differences between the private international law and public international law. Students, private international law is also known as law of conflict, where while public international law is known as law of nations. Second difference is private international law is that piece of law of any state which comes into activity when a court is called upon to decide a suit containing a foreign element, while public international law is designated as international law and regulate the relations between different countries. Third difference is national laws are primary source of private international law enacted by the legislature of the concerned sovereign state, while treaties, conventions, and international customs are the primary source of public international law. Fourth difference is private international law is differ from state to state, while public international law is applied uniformly to all the member states and its rules are same everywhere. Fifth difference is Private international law deals with the legal relationship that exist between private individuals, businesses, and other entities that conduct businesses in other countries. It addresses issues like the recognition and enforcement of foreign judgment, choice of law, and jurisdiction. Although states are not bound by private international law, national legal system recognize it as a set of rules as principles that governs cross-border transactions. On the other hand, relationship between states, international organizations, and other entities with international legal personality are focus of public international law. The use of force, diplomatic immunity, human rights, international trade, and the rights and obligation of states in their interaction with one another are the governed by it. Sixth difference is private international law is private because it regulates relation between private parties and includes civil and commercial law, while public law regulates relation between state and include the law of nations or public international law. Last difference is private international law is enforced through domestic courts and arbitration, whereas public international law is enforced through diplomatic channels, interaction, courts, and tribunal and economic sanction. Students, later part we will discuss in next lecture. Now I am closing my lecture here.